on that.
Good morning, everyone. Welcome to House Judiciary. This bright Friday morning. Debbie, you want to call the roll?
Representative Chestick? Here. Representative Crago?
Excused.
Representative Harrelson? Here. Representative Jennings?
Excused.
Representative Nemec? Here. Representative Oakley?
Here.
Representative Provenza? Here. Representative Rodriguez-Williams? And Chairman Washut.
Here. So a couple of our members are gone today. They've gone to the funeral in Sheridan today, so that's why they are absent. We're going to begin with Senate File 36. Senate File 36. Standard rules of decorum. Make sure your cell phones are turned off and be polite to one another. We'll have no problems. So Senate File 36, everybody remembers, is a joint judiciary interim bill adopting the Uniform Child Abduction Prevention Act that primarily allows the courts to get ahead of an abduction threat and to put in place some provisions that allow the court to require different things in order to discourage the possibility of a child being abducted by a non-custodial parent. That's the way I read the bill. Anybody in the audience wishing to testify about Senate File 36? Ms. Lance, you carried us through the interim on this bill.
Yes.
Hope you have great wisdom for us this morning.
Good morning, Mr. Chairman, members of the committee. My name is Beth Lance. I'm here as an attorney practicing in the area of family law here in Cheyenne and as a lobbyist for the Wyoming Trial Lawyers Association. I do stand in support of this bill, as do the trial lawyers. This is a piece of model legislation that is supported by the American Bar Association and is beginning to spread across many states and is quickly being adopted by our states. It does provide several tools to assist family law attorneys in a situation, as you described, where a non-custodial parent is a potential threat for abducting the children. And it gives a lot of ways in which you can go to the court and seek different potential preventative solutions so that hopefully these abductions happen less and less. We, as family attorneys, all can cite to examples where we've had this happen in our cases. It's obviously quite distressing. It's traumatic for the children. It's traumatic for the other parent. And so I think this is a great piece of legislation because of what it can offer our family lawyers and our court system to hopefully get ahead of this and prevent these kinds of actions from occurring.
Thank you. Questions for Ms. Lance? Let's talk a little bit about credible risk. Credible risk of abduction. That phrase is used in the bill extensively. Can you describe for us maybe a real life scenario where a judge might say that there was a credible risk?
Sure, Mr. Chairman. Obviously, that's going to be fact specific, and those are facts that would be presented to judges, and judges would make their reasonable determinations as to whether that were found to be credible. But there are certain cases where not only is it credible, I think it's imminent. We've had situations where parents have made very direct threats that they will, in fact, abduct the children, that they do, in fact, plan to leave the state. I had a case actually where a parent had ties to a Middle Eastern country, which would then not be a nation that would participate under the Hague in order for that child to be able to even be retrieved. back to the United States. And so sometimes it's to that level where the parent may actually feel that they really truly will never see their child again. And so it can be up to that level where it's quite serious. And this would provide things where you could put holds on that passport and be able to control that passport on behalf of that minor child, which would disallow travel with only that one parent to a country such as that. And so those are certainly examples of credible and obviously the most extreme examples. But certainly there are examples where parents are alluding to this or maybe have told a third party that they're thinking of this, things like that. And so those would just be things for the court to sort out as to whether that rises to that credible level.
Thank you. Was that a Wyoming case that you're referring to?
Yes.
Thank you. Always helpful on the floor.
Yeah, absolutely.
Representative Oakley.
Thank you, Mr. Chairman. Good morning, Ms. Lance. I guess I just was wondering, as far as the discussion with the Senate, if there's anything that they were particularly focused on or interested in. We're having that we meet at the same time, and we're having different issues come up and then not addressing them, and then bills are dying. So is there any, has there been any specific consternation with this bill so we can discuss it, if there has been?
Ms. Lance.
Mr. Chairman, Representative Oakley, I did listen in on that, and no, I wasn't picking up on anything specifically negative towards this bill. It seemed to be generally thought of as a tool that would be good and obviously available to either parent, and so I think there's no concerns that it's somehow unfair or something like that.
Thank you. Further questions? Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Ms. Lance, on page 20, the bill talks about granting any other relief allowed under the law of the state, and what the court may do to enforce the return of the child. Just curious what relief might look like. Would that include like any sort of victim services, or what does that look like?
Ms. Lance, if you know.
Mr. Chair, I apologize. I'm trying to find.
Line 16.
Okay.
Page 20, line 16.
Thank you. Mr. Chairman, the only thing that comes to mind here would be obviously to prevent this, they may make certain custodial orders as well, right? So if there's a current custodial arrangement where maybe that parent is supposed to have their visitation time or something like that, potentially a court could look at restricting that for the time being until they're confident that there's no longer a threat of abduction. So that's the first thing that comes to my mind that a court may look at doing under this. But I can't say that there aren't potentially other options.
Thank you. Further questions from Ms. Lance? Say none. Thank you for being here this morning.
Thank you, Mr.
And throughout the interim. You're
I
very
appreciate
helpful. Anyone else in the room wishing to testify on Senate File 36? Anybody on Zoom? Closed public comment committee, or your preference? Moved by Oakley, second by Provenza. Discussion?
I just had discussion.
Representative Oakley.
Thank you, Mr. Chairman. I guess I just want to say I appreciate the direction of this. We too just had a case that would fit under these sort of circumstances. And there was a lot of consternation and wanting law enforcement to go arrest, but it's a difficult thing because what happens is that expects law enforcement to know and believe the current state of a custodial order. And sometimes that's not easy. They might be old, or it might say, visitation, summer visitation or something. How do they know? So then you've got law enforcement trying to determine where they're at in a custodial order and using it under criminal law. This allows that the courts are looking at it. So, to direct the use of law enforcement to take action reasonable to locate the child and return. Then law enforcement knows, okay, this has been vetted by the parents, the courts, and I have no problem doing that. But making the determination if something criminal has happened and arresting people is just a higher step. So anyway, I appreciate the direction of this.
Further discussion? Representative Harrelson.
Thank you, Mr. Chairman. Agreed. I'm also going to throw out that anytime I see uniform act, I get a little scared for the simple fact that I struggle when we enter into those types of agreements and what may come of it in the long run. And so I don't have a problem with establishing lines of communication and all of those things. I do love that aspect of getting the courts involved where we're not just putting it all on the officer. I think that's a great thing. I've always struggled whenever we start entering into agreements like this with other states when it comes to commerce, when it comes to law enforcement, because it just sometimes means that, means that we're then stuck. I mean, we talk about it on corporations with energy policy. I mean, there's just, anytime you tie with other states, sometimes it can have unintended consequences. So that's, I guess, a little bit of a misgiving that I have on it.
Further discussion? I would just add that, we also have uniform standards that are quite beneficial, right? Like uniform traffic code and so forth, where the 8-sided red sign means the same thing in every state. I think that's advantageous to have some uniformity sometimes from state to state as well. Representative Chestick.
Thank you, Mr. Chairman. This is a uniform law. It's not a compact. A compact is something where we can't change the language. This one we can if we wanted to. I don't want to. I think it's a good bill, and I think having uniformity across state lines, because a lot of these abductions happen across state lines, is a very useful thing. So I'm very much in support of this bill.
Question being called. Debbie, you want to call the roll?
Representative Chesick,
Aye.
Representative Krago,
Excused.
Representative Harrelson, Representative Jennings,
He left a no vote.
Representative Nemec,
Aye.
Representative Oakley,
Aye.
Representative Provenza, Representative Rodriguez-Williams.
Aye.
And Chairman Washut.
Aye.
We have a total of 6 ayes, 2 noes, and 1 excused.
Okay, so we have a due pass on that. Do you have a volunteer to carry it on the floor? Representative Chestick, perhaps? All right. All right, that takes us to Senate File 53, Senator Bartle.
Good morning, Mr. Chairman, members of the committee. It's a pleasure to be with you here this morning. So Senate File 53 is an adjustment in the number of district court judges in the 6th Judicial District, which is Campbell, Crook, and Weston counties. This is a result of the caseload study report that was done, I think, maybe 3 years ago. And what the legislature did is we authorized or we placed a requirement on the county and on the district to build a new courtroom prior to authorizing the 4th judge that the case report showed was necessary to service the judicial needs in our communities. In late late last year, the construction was completed by Campbell County and the Campbell County Courthouse. It was too late to bring it to this committee, and the Chief Justice did that certification. So the county put in, I don't know, a couple million, $1 million+ renovated the courthouse, add a 4th courtroom, which was the requirement of the legislature. The Chief Justice brought that to the committee chairman too late in the interim process, so that's why you have a bill that's a personal bill per se, but certainly one that I think is appropriate based on where we are. The bill is quite simple, Mr. Chairman. It, as you know, in statute and both in statute and in the budget, we fund and authorize judges based on either codified statute, the number, and then in the budget, we fund them each by judicial district, each judicial district. So what this does is goes in and moves 6 judicial districts from 3 judges to 4. That's page 2 of the bill. And then there's the appropriation. Because it wasn't, anyway, wasn't prepared in time for the budget, it comes as a set-alone bill, both the appropriation and the number of judges. So, Mr. Chairman, that is the bill. If there's any questions, I'd be glad to try to answer them. I don't know if anybody from the court is here. I didn't look behind me to see if there's anybody from the court. But that's the bill. I'd be glad to stand for any questions, Mr. Chairman.
Any questions for Senator Barlow? Seeing none, call your backup.
Thank you.
Ms. Butler, good morning.
Good morning, Mr. Chairman, members of the committee. My name is Elisa Butler. I am the State Court Administrator for the Wyoming Judicial Branch. I don't know that I have much to add to what Senator Barlow provided to you today, but I'd be happy to answer any questions. I guess there is one thing I would like to add, and that is that really this 4th judge in the 6th Judicial District is going to better serve the citizens of the 6th Judicial District. Right now, what we have in the workload study is that we have 3 judges doing the work of 4, which means it takes a lot longer for people to get into court and get their cases resolved. And Mr. Chairman, I would just add that I believe we have Judge Healy here remotely. So I think he is also here to provide testimony if you need it. But again, I'd be happy to answer any questions that the committee may have.
Questions for Ms. Butler? Seeing none, thank you for getting up early for no questions. Bring in Judge Healy, please. Judge Healy, are you out there? Can you hear me? Judge Healy, are you out there?
I think I am now. Can you hear me, Chairman?
Now I can hear you fine.
All right, great. Well, thank you for having me this morning, Mr. Chairman and members of the committee. I really appreciate Senator Barlow being here.
Your Honor, would you state your name just for the record and then give us?
Yes, I'm Stuart Healy. I'm a judge in the 6th Judicial District, and I really don't have a lot to add. I just thought it would be good if you had a practical idea of the type of caseload that we have in the 6th Judicial District. We are setting right now, we're setting civil trials out about 18 months. And we are setting domestic cases. And I know that Ms. Lance spoke briefly about domestic cases. We're setting those out about 6 months, and they're stacked, which means they are usually we set a trial and we set 3 trials on the same day and hope that one of those goes. And the reason why that's important for the committee to know is that so many of those domestic cases involve the custody of children or the disposition of custody modification issues, and all of those cases that are delayed, of course, become concerns for us as judges and certainly for the people of the 6th Judicial District. And then on top of that, we have criminal trials that have a speedy trial and juvenile cases that have that have deadlines that we have to meet. So anytime those cases go, and I can tell you I have a trial each week now, a criminal trial each week for the next 5 weeks. Those civil cases that are put in those weeks are then moved even further out. So this is a really, really important bill for the people of the 6th Judicial District. And I appreciate all of you hearing it today, and I'm happy to answer any questions if you have them.
We appreciate you being here this morning, Your Honor. And any questions for the judge? I have one. Judge, is it still possible where occasionally you have a judge from another district come and offer some assistance to your district? Is that still occurring?
That's a great question, Chairman Washut. We do have that happen. In fact, all of our child support issues, we have Judge Kervin from Buffalo handle those for us because we simply don't have room for them in our docket.
Very good. Representative Provenza.
Thank you, Mr. Chairman. Thank you, Judge, for being here. I'm anticipating questions potentially on the floor, and I'm curious if you can tell us why the increase in cases. Are we seeing a population growth issue? Are we seeing complexity of issues? Just kind of speak to that and broadly.
Mr. Chairman, Representative Provenza, the fact of the matter is this is an issue that's been ongoing for some time in the 6th Judicial District. And the reason that we haven't been able to come forward before is that we didn't have the courtroom available. But if you want to see government in action really doing a great job, the Campbell County commissioners just put all of their resources into getting that courtroom done. And we, as Senator Barlow mentioned, we really tried to get it done and certified as quickly as we could. But it is the main reason that we haven't come to the legislature previously, despite the fact that we've had this workload for years now, is the lack of an extra courtroom. But now we have that thanks to the Campbell County commissioners.
Very good. No further questions. Thank you, Your Honor.
Thank you.
Further testimony on Senate File 53. Ms. Lance?
Mr. Chairman, Beth Lance, Wyoming Trial Lawyers Association. This bill has been presented to our board and our association, and the trial lawyers wholeheartedly support this bill. Our members that practice in the 6th Judicial District certainly can speak towards what Judge Healy just outlined as the unfortunate delays that are the result of the caseloads that exist in that district. And so certainly our attorney members would, on behalf of their clients, like to be able to see their civil cases be handled much more expeditiously, which we believe that the addition of this judge in the 6th Judicial District would facilitate. So we stand in support.
Thank you.
Thank you.
Representative Harrelson.
Thank you, Mr. Chairman, and thank you, Ms. Lance. Might not be directly in your wheelhouse, but we heard 18 months on civil cases is the timeline. Do we have an idea of what's normal? Like,
Ms. Lance, is there normal?
is there normal? Yeah. What's average? We'll say that.
Mr. Chairman, Representative Harrelson, normal is a good question. Obviously, sometimes these cases are delayed as a result of the case itself, not the court. I think the frustration is when the case is ready to go, which often domestic cases may be ready very quickly. They're amicable, potentially, things of that nature. They don't necessarily need to wait the 6 months. And so the hope is that certain cases that would not require a lengthy amount of the court's time, right? So if a trial needed 2 or 3 days, I understand that's probably where he's saying that's going to take 18 months or longer to get 2 or 3 days on a docket, on a judge's docket. But the unfortunate part is then people who maybe need 2 hours are still waiting that long. And so I think that's where it becomes abnormal and definitely becomes an issue for families who are seeking these domestic cases to be heard.
Ms. Lance, this might be a better question for Ms. Butler, but I'll ask you to see if you know. So when we have a judge from one district filling in the other district, the voters of the 6th Judicial District don't get to vote on the vote of retention for the judge from Johnson County. Is that correct?
Mr. Chairman, that is my understanding. That would be correct.
I get a nod, head nod in the back. Okay. Further questions? Seeing none. Anybody else in the room wishing to testify on Senate File 53? Seeing none, close public comment. Committee preference? Moved by Oakley, seconded by Harrelson. Discussion? Representative Oakley.
Thank you, Mr. Chairman. I just want to just say to support this bill, really to understand how a stressful a job being a district court judge is in the best of circumstances. They just deal with all of the difficult issues, felony, criminal, difficult family law, juvenile issues, complex civil issues. They're usually very, very impressive. And then if you add on top of that an overwhelming workload, it's just too much to ask. So this is important stuff. I appreciate what Campbell County has done in addition, as we heard, really locally taking the initiative here. And then finally, I guess, talking about the length of it, if you don't get a setting, think like people going through litigation, it's very stressful, right? And people want to find an end to it. And when you don't, imagine getting your date right now, saying 26, So that's hard on the people too. So this is great. I think great work has been done. Appreciate it. Stand in support.
Okay. Call the roll.
Representative Chestick,
Aye.
Representative Cragel,
Excused.
Representative Harrelson, Representative Jennings,
He left an aye.
Representative Nemec,
Aye.
Representative Oakley,
Aye.
Representative Provenza, Representative Rodriguez Williams.
Aye.
Chairman Washut.
Aye. And I'll
Have a
carry,
total of 8 ayes and 1 excused.
the bill on the floor. That brings us to Senate File 73, Senator Bartle.
Thank you, Mr. Chairman. Just a note on the last bill that also has an appropriation, so probably have to go through as you wish, but may have to go through your Appropriations Committee. Thank you, Mr. Chairman. So Senate File 73 is actually, you learn as bills become law, you learn things that you missed or weren't aware of. Senate File 73 is one of those. As you'll recall, Senate File 120 passed last year, which was a restoration of rights. It restored rights for one-time nonviolent felons, and they received the remainder of their rights 5 years post end of their sentence, probation, parole, all of their things. And we were, several of us, and maybe some on this committee as well, were contacted in the middle of the summer saying, hey, thanks, I got my rights restored, but now I find out I'm not eligible for a concealed carry permit. Can we do something about that? And so in conferring with visiting with the Attorney General's office, DCI specifically, because they are charged with concealed firearms permits. There's a specific prohibition for individuals who were convicted under a Controlled Substance Act. So if they were felons under the Controlled Substance Act, there's a prohibition in current law that says they are not eligible for a concealed firearms permit. Current law, and if you just go to page 2 of the bill, Mr. Chairman, and this is a really, this is like 2 pluses equal a minus, plus a minus equals a positive. This is one of those sets of statutes that, notwithstanding all these different things, it's very long and complex, but basically what it gets down to in the bottom of page 2, under current law, you're not eligible for a concealed firearm permit unless you've been pardoned. And of course, a pardon is a gubernatorial action. It's not anything the legislature has anything to do with. Constitutional right of the governor or privilege of the governor, not. And so what this bill does is it goes in and just says, or had their firearms restored under the two restoration components that are in statute. Now, just to recall for the members of the committee, 713-105A was current statute prior to the restoration bill we had last year. That's the governor's ability to restore someone's rights. That has been, I don't know how long it's been in law, but that's there. F, and it says A or F. F is what 120 added last year. And so, again, that's a one-time nonviolent felon, 5 years after they've completed their sentence, parole, probation. So that is the extent of this bill, Mr. Chairman. And the story that, came from the young man was made a mistake when he was 18 or 19. Now he's 15 years later, citizen in the community, business owner, et cetera. Thank you for restoring my rights, but I'd also like to be able to carry concealed for, personal protection, et cetera. So that's what this bill is. That's where it came from. Mr. Chairman, and I didn't look at it, I didn't look it up this morning, but as of the end of last week, 478 individuals had their rights restored completely under this. Now, there are, just to be clear, there are others who had put in an application that were rejected because they had some other disqualifier. And some of you have heard that some of those disqualifiers are federal convictions. And there is some ongoing discussions between the Attorney General's office and the U.S. Attorney's Office about how that's being handled. But under state law, these are convictions under state law. There's a clear nexus that we move forward with this. So be glad to stand for questions, Mr. Chairman, and thank you for your consideration.
Thank you, Senator. Questions for the senator? Representative Provenza.
Thank you. Senator Barlow, just a question that I anticipate potentially is how this impacts when you go to other states, because I think we have interstate compacts, right? Is that'll be fine? It's not going to harm kind of other states that are like, that don't give folks their rights back?
Reciprocity. Yeah, thank you, Mr. Chairman. So my understanding, and I don't have a depth of a deep well of understanding, is once a state that has a reciprocity agreement with other states, there is no other barrier. They will if we issue a concealed firearm permit, they will recognize that firearm permit. I don't know of any barrier to that at this point. And I can certainly be proven wrong, but basically that's my understanding. And I think I saw the map, and I think it's 33 states that we have some level of reciprocity with. I apologize, I don't know the immediate number.
Further questions? Thank you this morning.
Thank you.
Anyone else wishing to testify on Senate File 73?
My name is James Lake, and I'm here today as a citizen of the state of Wyoming and someone who is going to greatly benefit from this bill. I am a one-time nonviolent narcotic or drug offender for marijuana. Back in 1997, I broadsided a 3/4 ton pickup doing 50 miles an hour on a motorcycle. Guy didn't see me, pulled out in front of me. I went through 13 surgeries in 12 months, years of rehabilitation. The opioid epidemic, just in a horrific way, from the morphine I took straight in the neck for the first 2 months on down through the pills. And I can honestly say that marijuana saved my life. And it got me off the opioids, it got me off the alcohol, it took care of my depression and my anxiety. One of the most difficult things I've ever done was stand and look at myself in the mirror for the first time after my accident and see my disfiguration. And it really affected me. It really affected me. My family's been in Wyoming a long time. Guns have been hunting, has been a part of my life from the time I was a child. My grandparents built a small store in Glen Rock, Wyoming in the early 50s. After World War II, where we began processing wild game. I'm a graduate of the very first state mandated hunter safety course in the state from Glen Rock, Wyoming in December 1997. And my gun rights have meant more to me than I can ever say. I've never really been convicted of any kind of game and fish violations. So, I just spent 6 years in the university trying to educate myself, hoping that maybe I can become employed and support myself through the later years of my life versus the welfare system. And, I feel very vulnerable, being disabled and not having a way to protect myself. And I could go on and on and on. I don't believe I committed a crime in the eyes of the state of Wyoming. However, not only was I saving my own life and taking care of my own health, but I was actually out there educating people. You may have run across an email I sent here a while back, like at the beginning of last semester, kind of hoping that maybe we could move a little ways on that front. I mean, I know it's kind of unrelated, but we make the stuff that's actually safe and effective illegal and let the hemp people create these synthetic.
We do need your testimony to be specific to this bill.
I'm sorry. So anyway, I support, I'm wholeheartedly in support of this. I can't thank the state enough for giving me the opportunity to get my guns back. And I'm actually, I've applied to be a Wyoming game and fish hunter safety instructor. And I actually hope that maybe if I can achieve that I can teach my first class in the very same classroom that I took it in, which would be a real great. And getting my concealed carry permit would be a part of that. There are lots of other certifications. Marksmanship is one of my favorite activities in the whole world. Anyway, so thank you very much for your time, and have a great day.
All right, hang on to questions. Representative Oakley.
Thank you, Mr. Chairman. 2 questions. And so and if you want to say, and feel free to decline, but so just from your story, I'm just interested, was it a felony DUI or felony amount of marijuana? Go through the chair.
Mr. Chair, Representative Oakley, it was possession and distribution.
Okay.
Follow up.
And just briefly then, because we did pass this last year, so have you had your rights? I know you're interested in concealed carry, that's great, appreciate it. But have you had they've been restored pursuant to subsection F of what we?
I have not.
To the chair.
Mr. Chair, Representative Oakley, forgive me. I have not actually applied. I've been very, very focused on my education at the university. And particularly this semester is brutal. But it's certainly something that I plan on doing here in the very near future, especially should this legislation pass or whatever. I'm sorry, did Representative Oakley, Mr. Chairman, did you say that this provision has already passed?
The ability to get your rights restored has already passed.
Okay. Thank you for the clarification, Mr. Chairman.
Okay. Further questions? Seeing none, thank you for coming today.
Thank you.
Anyone else wishing to testify in Senate File 73? Anybody on Zoom? Committee or closed public comment? Preference? Move the bill by Provenza, second by Oakley. Discussion? Representative Provenza.
Thank you, Mr. Chairman. I just want to thank the senator for bringing this bill, and for Senate File 120 of last year. 478 people having their rights restored is awesome. And I look forward to supporting this bill as well. Thank you.
Representative Haroldson.
Thank you, Mr. Chairman. Just kind of maybe a point of clarification too. From what Senator Barlow said, very much true, and kind of what I've done research with Department of Correction is if the rights were removed in Wyoming, they can be restored in Wyoming, and it clears the NICS, and it gives them that freedom 100%. Obviously, the conversation here is the federal side, and that's an area that the state's going to have to work on. So my view is this: if we've restored your rights, then you have your rights. And so this is a no-brainer. This is definitely an awesome opportunity to say, yeah, we truly believe you have your rights back, and here's a way we can show that to you. So on and for.
And that's certainly sentiment I've gotten from talking to people in law enforcement is they assumed that this was part and parcel of getting your rights back, and so here we are. All right. Question being called. Debbie, you want to call the roll on Senate File 73?
Excuse me, Representative Chestick? Representative Crago?
Excused.
Representative Haroldson? Representative Jennings?
He left a aye vote.
Representative Nemec?
Aye.
Representative Oakley?
Aye.
Representative Provenza? Representative Rodriguez-Williams?
Aye.
Chairman Washit?
Aye.
We have a total of 7 ayes, 1 no, and 1 excused.
Senator.
Thank you, Mr. Chairman, and I apologize, Mr. Chairman, this was something that came up on the Senate side, so people that are interested with it, some of the discussion that comes up is, if you have your rights restored, under current law, you could actually carry constitutionally concealed, but you would not be eligible for a permit to be concealed. So I apologize that was actually part of the discussion on the Senate side that was brought out. Second thing, Mr. Chairman, I'd say, and I certainly appreciate there are nuances in restoration that still need to be addressed. But I was actually contacted last week by a gentleman who had lost his rights in the late 80s and had his rights restored and just received his FFL. So now he's going to be, that's a whole nother level of background and all that. So I think there is a trajectory here. We're going the right way. Maybe every step isn't perfect, but I think this is a very simple and straightforward step. So thank you, Mr. Chairman, and whoever decides they wish to carry on this on the floor, I'd be glad to visit with them if they would so choose. Thank you, Mr. Chairman.
Representative Nemec, you're a co-sponsor on this bill. Very good. All right, that concludes Senate File 73. Senate File 123, Representative Angelos. Always nice when a co-sponsor can pinch hit.
Mr. Chairman, committee, I bring to you today Senate File 123. There's no fiscal impact, so that always makes us happy, and it makes for a quick look. What this is authorizing natural or adoptive parents or legal guardians to change their minor child's name without giving public notice of the name change. So this was an issue that was in one of our communities where parents had, they were natural parents, had wanted to change their children's names. Being that it's a small community, they didn't really want it to be talked about. They didn't want teachers knowing, they didn't want friends or parents knowing, and so they asked the judge if they could not post the notice, the public notice, and that was denied. And so doing my little research, asking some friends that are lawyers, they said, yeah, it really is or judge's discretion on if the notice has to be posted. I have some background on this with my own family, with some family members. They did end up changing their minor children's names, had full support on both sides of all parents, and they didn't have to post notice. So that's really what this bill is addressing, is protecting our minor children, specifically in small communities that maybe you don't want things getting around, and that's where I have, and I'll stand for questions.
Questions? I just have one. I think I understand, but is it possible that there could be additional adoptive parents who aren't known to the court? And so when it says that all the natural and adoptive parents have signed the petition, how would the court know that all of those had signed?
Mr. Chairman, so I believe that this would only come into play if all parents, whether they're, like in this case, they were natural-born parents, all parties were petitioned to that. And from what I'm looking at, it says that that they would, I think that they would sign something with the judge. But I mean, you would definitely want all parties in agreement.
I would agree with that. I just don't know how you would know for sure that you had captured all the possible parties on there. Anyway.
Mr. Chairman, maybe one of our lawyers might know how they would do that with a judge.
I would assume that everybody knows who the adoptive parents are, and they would testify before the judge that that wasn't an exhaustive list, of what I anticipated, but as I reread the bill at 11:30 last night, popped into my mind. Any further questions? Anybody else wishing to testify on Senate File 123? Seeing none, nobody on Zoom. Close public comment committee. Question? Let's move the bill, okay. Moved by Haroldson, second by Provenza. Discussion, Oakley.
Thank you, Mr. Chairman. So just to address what I think was your question, I think this covers it, and I don't see an issue because of the ors. So I think it would be of record who is somebody's, like, because it has or, right? So natural or adoptive parents or legal guardians. And whoever is a legal guardian or the adoptive or natural parent will be of record. So I don't think this would have to include like natural and adoptive parents, so you've got people that you don't know. So I think the ors cover that, and it would be the guardians or whoever that is of record.
Very good, thank you, appreciate that. Question being called. Debbie, call the roll on 123.
Representative Chestic,
Aye.
Representative Kragle,
Excused.
Representative Haroldson,
Aye.
Representative Jennings,
He left an aye vote.
Representative Nemec,
Aye.
Representative Oakley,
Aye.
Representative Provenza, Representative Rodriguez-Williams,
Aye.
and Chairman Washut.
Aye.
We have a total of 8 ayes and 1 excused.
And who wants to carry that one?
Krago's on it.
Okay.
Stith and Weston.
It's Abby's.
Abby,
You're on.
pinch hit for judiciary.
All right, we are done until Monday, and Monday we will have another 7:30 meeting, so. Two bills, one vote.
All right.